Now that a jury has convicted former police officer Kim Potter, the next phase of this trial is sentencing. Still with me, criminal defense attorney Sam Braverman and Ryan Jones, and our legal contributor Paul Henderson. Ryan, Attorney General Keith Ellison asked for a fair sentence. In October, prosecutors informed the court that they were going to seek a more severe penalty than state guidelines call for, claiming Potter abused her position of authority and caused greater than normal danger to the safety of others. What does a fair sentence look like to you?
I think when you talk about fairness, you have to talk about general deterrence and the idea that you're guiding not just the behavior of this officer, but other officers and other people who run into similar situations. And what's fair would be to guide the actions of others in the future.
Paul, both sides will be making arguments before the sentencing hearing in February. What does the prosecution argue?
Well, the prosecution is going to argue and remind everyone that Daunte Wright is dead. We'll never see him again. If we truly want to honor his memory, that we have to sentence someone appropriately. And in this case, because we have the max for the first charge is 15 years, the max for the second charge is 10 years, I suspect that we're going to see something between 11 to 14-ish years. But what's going to be important that I'll be paying attention to is the presentation from the family that are going to get to testify, that are going to get to talk about Daunte Wright and his significance, not just to them and to their lives, but to the community as well. And that's the part that I think is relevant, that should weigh in the sentencing more about the implications for the rest of the community for an unarmed Black man to be killed by an encounter by police again, and what that means, how that serves as a sentence, as a model for the rest of the country, as the rest of the nation, and for that department, which still has not updated their use of force policies. That's the problem, and hopefully the sentence will speak to that.
Sam, what will the defense argue?
Well, I think you're going to hear a lot of what they argued today in their bail. That she's a 26-year officer. They're going to give a list of her citations. They're going to talk about the various different aspects of her life, the community things. They're also going to seek to fight against the departures. So as you heard a moment ago when they were just talking about bail, they talked about dispositional departures. There's also duration departures. I read the statute. It's not my state, but as I read it, the presumption is 86 months with the range 15% lower to 74, 20% higher to 103. So essentially 7 years with the flux down to 6 and up to about 9 or slightly less than 9 on the man 1. And the man 2, 4 years, 4157 on the range there. The hard part, and I think Ryan's point is a really important one about general deterrence. The hard part is that I think this case is not the best vehicle for general deterrence. I think most officers view this as an error. I think most officers view Chauvin as a monster. The ones that I think that make the greatest differences, and they failed in Baltimore, where they didn't hold the other officers accountable. And do they hold the other officers in Chauvin accountable in the next trial that's coming up? That's the one I think makes the greatest impact. Does somebody else say, hey, step in here and solve the problem? Somebody should say, Potter, you have your gun in your hand. Get that gun away. Somebody should say, Chauvin, get your hand off this guy's neck. I mean, that's the things that have the great general deterrence. I'm not sure the officers here feel that way. I'm going to guess 86 months or something in the 74 to 103 range.
All right, Sam Braverman, Ryan Jones, and Paul Henderson, thank you all for your insight and for spending your evening with us. I appreciate all of you. Happy holidays to you guys.